order. Thank you for joining us during our weekly hybrid MLS breakfast meeting. My name is Jolene Tu from REMAX.
I put it up there for you.
And I'm your March program chair. We will have Brandon Sorensky from First American NHD to guide us in our Pledge of Allegiance. So if everyone may please stand and put your hand.
All right. Good morning, everyone. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice.
Thank you, Brandon. And now we will have William Way from Pinnacle to give us our inspirational quote of the day.
Morning, everyone. My name is William, and the quote of the day is from John Lennon. Count your age by friends, not years. Count your life by smiles, not tears. Thank you.
Thank you. And again, I'm Jolene too from REMAX My Home. I think for the last couple of weeks, I already given my background several times. I think you're probably tired of hearing about me. But what's interesting this week? It's my birthday month. Okay. I know I'm old this year because I can't remember exactly how old I'm turning. That's what you know. When I've heard people say that, like I think I'm turning, I'm like, how do you know not know how old you're turning out? It's my turn. So yeah, I don't have anything planned so far. We'll see. Maybe watch maybe. Oh no!
Yay. Happy birthday to you. Happy birthday to you. Happy birthday, dear Joan. Happy birthday to you.
Okay. Hi, Day. Thank you. Thank you. Okay, so we'll just go with the rest of the agenda. So if you are a member and would like to make an announcement, please fill out our announcement form located to my left. Please return the forms to Lynn and then we can make the announcements during our meeting. Thank you. A few housekeeping things. All participants will be muted upon entry to the MLS breakfast meeting. And should you have a question or a comment, please remember to enter it into the chat box. Please remember to join us weekly as we will have our hybrid MLS breakfast meeting every Thursday at 9 a.m. As always, this meeting is being recorded and will be available online on our YouTube channel, West Newport Valley Realtors. Please remember to follow WSGBR social media on Facebook, Twitter, and Instagram. You can also watch all our pre-recorded videos on YouTube. Join our text message group. For updates, text WSGBR to the number 888-301-2201. Today's agenda consists of our affiliate spotlight, Marina Chang, Prime Lending, and our guest speaker, attorney Dee Lee from Dee Lee Law. Just a reminder that to be eligible for today's drawings, you must be a WSGBR member and be present in person at the association. We'll be having an attendance drawing, Amazon gift card drawing, and 50-50 raffle. Today, our affiliate spotlight will be brought to you by the affiliate chair, Lena Sankari. Sorry, I keep saying that wrong. Sankari of U.S. Bank and Vice President Teresa Nguyen of Loan Direct. Please remember to support our affiliate with your transactions. Take it away, Arena.
About prime lending, we originated in 1986. We're in all 50 states. And we have core values: honesty, integrity, service. Difference is customer service. We've got numerous awards. We are a big powerhouse and we have over 400 products, including renovation, 20 renovation older products. We have stated income right now. And we have the announcement system where we can do alpha, we get the 1% down and we sell.
I'll move it forward. Do you want to go forward?
I'm gonna show some pictures about our vacation. So Vacation. Last year we went to Hawaii. That's one of our famous hobbies. We love to travel. That's more of Maui. We went to Banff, Canada, for my son's friend's wedding. Yeah, the scenery in Banff is unbelievable. That's my family. Yeah, they hated me dressing in white. But when all the tourists were.
Not today, all affiliates present today, please line up at the front. There's no promotions, this is the morning greeting only, we will begin with affiliates in person.
Hi, everyone.
Yes.
I'm Cosmo Sanchez. I am a lender with New Aid Funding, mortgage lender.
Hey, everyone, this is Karen from General Mortgage Capital Corporation. Have a good day.
To say hi to you.
Good morning, everybody. This is Lucia Cam representing Campan Chinese American Real Estate Professionals Association. Good morning, everyone. This is Esther with HSBC Bank. Thank you. Have a good day.
Good morning, everyone. Brandon Spransky with First American NHD. Have a fantastic day. Good morning, Chase Kerr with Morris Plus Property Inspections.
Thursday, Dina and Karen from US Bank Home Mortgage. Pasadena. And good morning. I almost tripped and spelled for the money. Angie Tang, First American. Have a good morning. Good morning, Oriana Shan with Crack London, and I brought a guest, godson.
Thank you. My name is John with Budget Blinds.
Morning, this is Master Alex. And Master Bishop. Nice, sunny day. Thank you.
Morning, this is Ken Shen of Trans Global Private Lending. Have a great day. Thank you.
Good morning, everybody.
Good morning, everyone. Nancy Chan, lawyer's title. Thank you.
Good morning, everyone. Sage Gomez is my NHG, and have a great day.
Good morning, everybody. Richard Zaletta with ACG Funding. It's pretty good news. I just got promoted to vice president. Frame of home call home warranty. Today must be National Tax Day. Everybody wears their hat. All of a sudden, I have so many competitions. I have your winning ticket, so I take it to win. Thank you.
Here's another hat. This is Teresa. You can see me from Corinthian Title Company. Thank you.
Morning, Bob, too, with Champion.
Good morning, everyone. Yolanda Martinez and as WMG National Title Company. Have an awesome day.
Good morning, it's Nancy Wong with Lone Drive, have a wonderful day.
Just made it. Chris Hahn with Guild Mortgage. Have a great day, everyone.
Next, we'll call on affiliates who are joining us virtually. We have Unita Wu from Home Warranty of America.
Give me 1 second to unmute Unita.
There we go. Hi, everyone. Unita Wu from Home Warranty of America, the 13-month home warranty. Please let me know if there's any home warranty needs. We're here to help you. I do speak English, Chinese, Mandarin, and Indonesian. And thank you again for all your continued support. Have a wonderful day.
And next we have Judy Chow, AA Capital Investments.
Good morning. This is Judy, Senior Loan Officer, AA Capital Investment. I've been in this field serving community for over 30 years and have a great week. Thank you.
And we have John Wax of Snap NHD.
Good morning, everyone. John Wax with Snap NHD, Natural Hazard Disclosures for all your NHD tax environmental needs. Stay safe and have a wonderful day and a great caravan. Thank you.
Sorry.
Thank you.
Next we have Mark Wu of Laveau Insurance Services.
Good morning, everybody. We'll be springing into actions for your property insurance needs. And if you are involved in an accident or if your kids are and you just need some guidance, I'm here to help you as well. But hopefully you guys don't get into that situation.
And we are happy to include open pitches to our hybrid MLS breakfast meeting Remember, if you'd like to pitch your listing, you must go to the WSGBAR.com site, click on open pitch, fill out the caravan request form, and submit it no later than Thursday midnight of the week you want to pitch. Today, we have no business featured. Join us today. We have attorney Dee Lee of Dee Lee Law, and lawyer Lee was originally born in Shandong, China, immigrated to the United States at age 13. She attended UCLA and received a bachelor's degree in economics and international studies at UCLA with a magna cum laude. And then she graduated from Pepperdine University of Law, where she received her Juris Doctorate, along with a certificate of dispute dissolution. Today, Ms. Lee will be talking about eviction law. She represents landlords in unlawful detainer cases. And please help me welcome lawyer Lee.
Hi, everyone. My name is Dee Lee. I am the owner and managing attorney of Dee Lee Law Professional Corporation. It's a pleasure here today to meet all of you and do the presentation. So I only have about half an hour, and I will try my best to cover the topic of eviction in California. So get started. Friday. So first and foremost, I'm going to give a disclaimer. This is actually requirement by the state bar. The presentation today is purely for information purposes. It does not constitute a legal consultation. But of course, if you have any questions, especially specific legal questions, you're more than welcome to reach out to my office and schedule for a consultation. So I will go through these definitions as I go over the slide. First, what is an unlawful detainer? So unlawful detainer is the legal term for eviction. Eviction is more like a layman term for unlawful detainer. So it's a summary proceeding for a landlord to recover possession of the leased premises from a tenant wrongfully withholding or detaining the property. So this is a definition provided by the California Civil Procedure Code. So as you can see, there are a few key terms here. First, a UD is a summary proceeding. So summary means it's a lot shorter, a lot quicker. It's an accelerated process. As you may know, a civil litigation takes a long time. Okay, so it can take even up to a year or longer. But UD, because of its nature, it's urgent. The landlord needs to regain possession of the property as soon as they can. So we have this special procedure designed for this need. For example, once you start the UD case and you serve the papers to the defendant or the tenant only have 5 days to respond. Whereas in a civil litigation case, they have 30 days to respond. So this is a very unique distinction. And this 5 days does not include any weekends or judicial holidays. For example, if you serve the plaintiff and you serve the defendant, the sudden complaint and all papers say on Wednesday, and then you have Thursday, Friday, Monday, Tuesday, Wednesday. So Wednesday is the 5th day, the last day for the defendant to respond, assuming there's no court holidays or no judicial holidays during this 5 days. And if the defendant does not respond on the last day, on Wednesday, then the plaintiff could file a motion for default or request for default from the court or from the clerk, meaning that the defendant will lose because it missed the deadline to respond to the lawsuit. So I will also discuss the details in the later slides. So for UD, because of this, summary nature, it's quite different than a regular civil litigation. So it's highly advised that you seek legal counsel from attorneys that have experience in this. Not all litigation attorneys handle UD because it's okay. So next paragraph says a tenant is guilty of unlawful detainer when he continues in possession of the property without the permission of the landlord after default in the payment of rent and 3 days notice in writing requiring its rent payment. So here it's important to note that so this code mentions the 3 days notice. We probably all have heard the 3 days notice. Okay, the full name is called 3 day notice to pay rent or quit. So like the name suggests, the tenant is given this notice And he's basically given 3 days to do two things. Either move out, you vacate the property, or you pay rent. So if the tenant doesn't do either one, it refuses to leave, to move out, and it refuses to pay rent, then that's when the plaintiff or the landlord can initiate a lawsuit against it, which is called an unlawful detainer. And there are a lot of legal requirements regarding what a 3-day notice needs to say. And I know that a lot of people, they go off the internet and download the templates of 3-day notices and try to serve the tenants with that. And unfortunately, a lot of them are not efficient and they're not effective notices. So again, I highly recommend and suggest that if you are in a situation where you have to give your tenant a notice, whether it be a 3-day notice or a 60-day or 30-day or any type of notices, you should consult with an attorney to make sure that it does meet all the legal requirements. Because if the notice is ineffective and you serve that to the tenant, you could lose the lawsuit. So it's very, very crucial that you give the correct type of notice. Things like this. So there are a lot of different rules and laws that regulate unlawful detainer. There's laws from the state level, from the county level, and you probably know that LA County is probably one of the counties that provides the most protections to the tenant. And that's why evictions in LA is a lot more difficult than elsewhere. So not just that, there's also on the city level, there are ordinances and moratoriums. So as of today, the LA County eviction moratorium is still in effect. It's supposed to expire at the end of this month, March 31st. But we don't know if that's going to be continued or not. It has been continued for quite a few times. It was supposed to originally expire end of last year and extended again and again until potentially end of this month. So we will be watching and see if finally going to be over. But even with the moratorium in place, keep in mind, eviction is still possible. Okay, so the moratorium does not say that nobody can evict for no reason. That's not true. We're doing eviction since the pandemic, since 2020, and we've successfully evicted a lot of tenants who failed to pay rent. So it all depends on the reason why you're trying to evict. And I can also talk more later. You have to evict with the correct reason or ground. You have to have just cause. But once the eviction moratorium is over, then you should be able to evict for different kinds of reasons, not just for non-payment of rent. But just keep in mind, moratorium does not mean no eviction at all. So every case is different, and we have to see all the fact patterns and see the lease agreements, understand why you're trying to evict. So it's quite complicated to make a judgment call. So if you're not sure about whether you should evict and how to evict, again, consult with an attorney. Slide, please. So the question is an unlawful detainer required? Many clients might ask me, is there other ways to evict? Because we all know eviction takes a long time, it's quite expensive. You have to pay for court fees, attorney's fees, and even fees maybe to the sheriff to perform the final lockout, or even fees to process servers. So, and unfortunately, it is required, and it's the only way to lawfully and correctly evict someone. And people think like, okay, so can I just change the locks, cut the utilities, turn off the heater, and so forth? Of course not. You cannot do any of that, and please don't do that. Okay, I've had people who have tried to evict through the self-help ways, and it just makes the eviction process even more difficult and longer, because you give a tenant a reason to not move because you've done it. You've done something wrong, and they have a defense to prolong the process. So self-help is strictly prohibited. And well, unless your tenant moves out voluntarily and completely, you unfortunately have to start this legal process. Next slide, please. So how do I know if my tenant moves out or not? There's also a question that comes up quite often. You know, there are situations where, you know, it's the beginning of the month and time to pay rent, and you haven't received the rent payment. You try, you know, calling the tenant, no one picking up, texting the tenant, not responding, right? So what's going on? And the key here is whether the tenant has returned the key to you. So that's the general rule of thumb. If the tenant is still holding on to the key, then you're safe to assume that he or she has not moved out and is still, you know, living on the property. So in that situation, if you want to start eviction, for example, for the reason of non-payment of rent, then you have to start the unlawful legal process. There's also another way of, rather than starting a UD, there's also another way to like end or terminate this relationship is by giving a so-called notice of leave of abandonment. So this is written in the California Civil Code 1951.3. It's basically a notice that you give to the tenant and tell them that it's been 14 days of non-payment of rent. And now as a landlord, you have reasonable belief that the tenant has abandoned the property, basically has already moved out. So you have this notice, so it's a notice of belief of abandonment. So, and then the notice will have to give the tenant some time to respond and let you know that he's not abandoning, that he's still living on the property. So you can give this notice if you're not sure whether the tenant is still living on the property and you're not sure if you want to just go ahead and start a UD, then this notice is something that you can give. That's a very good question. So for any type of notices, you have to give it to the tenant. So there's different ways of serving the notices. And of course, the most straightforward and direct way is by serving personally, meaning you have to personally deliver the notice to the tenant. But in this situation, you don't know where the tenant is, right? Like he's not at home and he might be on vacation or out of town. What you can do is by serving through posting a copy on the door and mailing it to him. So there are all these methods of services are also written in the law. So that's something court attorneys can instruct you on what to do. So very quickly, what does an UD look like? So we put like this simple 3 steps to describe a UD process. But this 3-step thing could turn into a 30-step thing, and it could take months and months. But we can just say that, you know, step 1, you have to give a notice, whether it be a 3-day notice or a 30-day or 60-day, depending on the length of the lease and the nature of the notice. And also step 2 is that you have to file this lawsuit, right? This UD proceeding by filing a complaint with the appropriate court. And last step that is after you win this lawsuit, you have the judgment and writ of possession. You give it to the sheriff for them to perform the final lockout. I will elaborate on step 2 because this is basically the step that involves the entire UD proceeding. So first, you want to file. So at this point, you've already given the tenant a 3-day notice to pay rent or quit. And the tenant has not paid you any rent and still living on the property. So you have to file a complaint, right, with the appropriate court. It's not all courts in LA or any county handles UD. In fact, not every single court has a UD department. There are only specific courts that handle UD cases. For example, we're in San Gabriel. So most likely the properties here will either be, if you want to evict someone who's living in a house in San Gabriel, you most likely will have to file it with the Pasadena court. Or maybe some of the cases have to go to Stanley Mosque in downtown LA, but those 2 courthouses are the ones that would have jurisdiction over UD cases in San Gabriel Valley. We've also dealt with courts in, you know, Riverside, San Bernardino, and Orange County, and different courts have, you know, different speed on how quickly they can handle those cases. And fortunately, Los Angeles County Courts is quite fast. Anyone can guess where the slowest court is out of the ones I just mentioned. San Bernardino. San Bernardino is extremely appreciably slow right now, and we're just, yeah, it's unfortunate that a lot of our clients are very frustrated because the court is taking forever to even process our complaint. So, but for you guys, if you have properties here that you're managing in LA, it's not as bad. And Pasadena is actually quite. So after you file the complaint, you have to serve the summons and complaint on the other paper to the defendant, which is what I discussed earlier through the service process. And after the defendant has been successfully served, he or she will have 5 days, like I mentioned, 5 days to respond by either filing an answer to the complaint or some sort of a response pleading via demurrage, via motion to dismiss, via motion to quash, etc. So, and this is where it gets tricky, okay? If the defendant does not respond in 5 days, then you can get a default. And this is the best case scenario because it will not take that long. Probably take up to, I would say, a month and a half to 2 months, then you will get, the final judgment from the court. And then you can deliver the judgment and writ to the sheriff and have the sheriff lock the tenant out. That's the best case scenario. That's what we are all hoping for, okay? But there are cases where the defendant, the tenant is very litigious. They think that they're wrong, they shouldn't be evicted, they have reasons why they're not paying rent. So in those cases, then they will respond to the lawsuit, and they might even try all kinds of delay and tactics to hold on this UD process. So, which makes the case a lot harder and time consuming. It could take up to, I would say, 4 months or even longer. And if you have a case in San Bernardino, you want to plus another 2 months on top of that. Okay, so yeah, a lot of people ask me like, how long does the UD take? That's what everyone's concerned with, right? Well, there's unfortunately, no fixed timeline. It all depends on the complexity of the case, whether the defendant is, aggressively defending themselves in a lawsuit. But on average, about 3 to 4 months from start to finish. Okay, so also I want to go back to step 3. You submit the writ to the sheriff. Okay, writ is the court's final order. So the full name is called writ of possession. Okay, for a UD case, it's writ of possession. Keyword possession. Possession means that you now can have possession of the property. So even though it's your house, you're the landlord, but the possession was in the tenant because you leased the property to the tenant. But now you can regain and have the possession of the property back to you. That's all a UD case will do, which means you're not going to get monetary damages. The court will not order in the writ of possession that the defendant have to pay you money. The defendant it does not mention any of that, okay? The possession only means that you can now have the property back. You could go to small claims, depending on the amount of your damages. You can go to small claims or a regular civil court to seek compensation for your monetary damages. So this is a very, very important distinction. Because a lot of people assume that, okay, once I have my tenant evicted, then the tenant will pay me all my rent back. That's not true. You have to do so via a separate case, basically, because the UD, all it does is returning the possession of the property back to the landlord. Okay, so like I said, the very, very first step of a UD is to give a notice to the tenant. So what kind of notice should I give? Okay. There are different kinds of notices with different purposes. So the most common one is the 3-day notice to pay rent or quit, which is the most common one we see in the UD case. You give this to the tenant if you don't receive rent and you want to, start the UD process, then the 3-day notice to pay rent or quit is what you have to begin with. There's also the 3-day notice to form a covenant or quit. So this specific notice is used when the tenant violates certain terms of the lease agreement. For example, the common one we have seen is that, the tenant is not allowed to have pets in the apartment. Then you notice that there is a pet in the house, and that violates the agreement. So then you can give the tenant 3 days to somehow, get rid of the pet, give it away. Otherwise, basically perform the covenant to fix the problem, right? Or you have to leave. So that's what a 3-day notice to perform covenant quit means. And there's also the 3-day notice to quit. So this one refers to situation that's more serious, that you're not even giving them a chance to remedy, they just have to move out because they have committed really serious nuisance, waste, or unlawful activities. Like they are, I have seen a lot of cases where tenants are growing marijuana. This is very common, especially in Corona and Eastville, in those properties, in those areas. I don't know why, something about the land there or something, which is very common. And there's also the 30-day notice and the 60-day notice. So here, I also want to bring these to your attention. It's very, very important to know the differences, okay? So when do you give a 30-day notice? Well, the full name is 30-day notice to terminate, or basically terminate the lease, right? You give it to the tenant when the tenant has been living on the property for less than a year. If you want to, so the tenant has only lived there for maybe a few months, less than a year, and you don't want to lease it to them anymore, then you give them a 30-day notice. But if the tenant has lived there for more than a year, you must give a 60-day notice. So please remember that.
Question about the 30-day notice to quit.
Yeah.
Is there a place where we can find a list of what is considered as serious nuisance?
Yes, there are examples in the code. So nuisance and waste. I have seen a case where the client has been hoarding a lot of trash in the backyard. It's gotten the city's attention, and the city issued a ticket or some sort of violation citation for the landowner. So this would be a nuisance, a serious nuisance. And also if it also harms the just the regular enjoyment of the property, then it's really fact intensive. So we have to see, it's a case law. Yeah, case law. And also the code provides examples of what a nuisance is. Yeah. But just remember, I have seen a lot of clients who complain about their tenants because the tenant's really loud, or certain habits that the landlord does not like. Well, those situations probably will arise to the nuisance or the waste situation. So we'll have to see. It's very fact intensive.
For the 30-day notice, what if they're still within their 1-year lease term? Can we still, within that year, they want to be evicted?
So the 30-day notice, it really depends on how long the tenant has been living on the property, especially in a month-to-month situation, or in a 1-year lease. Before the lease, when the lease ends, you did not expressly terminate the lease with the tenant. Then it becomes a month-to-month after that 1 year. So if say the tenant has lived on the property for 1 year and 1 month, and now you want to evict him or you want to terminate the lease, you have to give a 60-day notice because the tenant has been living there for a year. So you have to look at the aggregate time of the tenancy.
Okay, let's move along.
So this is just what I just mentioned, okay? So an expired lease agreement may automatically turn into a month-to-month tenancy. So what's the takeaway? If you have a fixed 1-year lease and you're sure that you don't want to continue the lease with the tenant, then you make sure before that 1 year, that anniversary date, you give a very explicit, clear notice that you're no longer renewing the lease with the tenant. I would give that. You have to give a 30-day notice because it has been 1 year. So don't wait till no, it's only maybe 10 days left till that 1-year anniversary date, then you most likely will run into this month-to-month situation because the lease will automatically become a month after that 1 year is expired. And yeah, again, self-help eviction not allowed. Don't do that. So, and how does the COVID-19 affect eviction in California? So ever since I would say early 2020, California state and all the counties and even some cities have enacted a series of laws and rules, ordinances protecting the tenants from being evicted. And like I mentioned, there's currently still a eviction moratorium that's in effect. So these moratoriums are designed to protect tenants who have been adversely affected by COVID-19. So for tenants who have lost their job, who have, for business owners who are like, bankrupt or their business are closed due to COVID-19, you cannot evict them if they're not paying rent because they're suffering financial hardship with COVID-19. So that's what the eviction moratorium is designed for. And unfortunately, a lot of tenants are taking advantage of that. They're using that as an excuse to not pay rent. So it's very important for you to know that it's still possible to evict, but you have to be very careful and be mindful whether the tenant has given you any sort of notice or disclosure about their financial hardships. If they have not mentioned anything about COVID-19, and if they have been paying rent regularly until, say, like this year, they're all of a sudden stopping the rent payment, then most likely they're not affected by COVID-19. So, and also there are specific rules that you have to follow to evict someone because of the moratorium. There are specific languages you have to include in those 3-day notices, which is why a lot of the templates that I have seen people use from the internet are not effective notices. And also, we're in California. It is a very pro-tenant state. Judges are very tenant-friendly. We have dealt with many judges who you can just tell they're like favor the tenants, and they want to give the tenants some time to pay up rather than evict them. And this is also because homelessness is such a serious problem in LA. So there are public policy reasons behind this too, which makes things a lot harder for landlord. And I understand that it's probably not fair for the landlord, especially individual landlords. We're not talking about big corporate landlords here. Okay, I don't represent them. We're talking about individual, personal tenants, the landlords who also have mortgages that they have to pay every month. So they're under tremendous pressure dealing with tenants for behind on the rent payment. But there are hope. Still have faith in the legal system that we can help those landlords to successfully evict tenants for violating the rules. So that was a quick. I think that's the last.
Yeah, that's the last
was a
one.
quick overview of eviction. There's still a lot to talk about. Do I have time to talk about the other topics or no?
I think we've got quite a few questions on Zoom.
Okay.
I don't know if any of the-
Oh, yeah. Okay, just a quick reminder that I'm not supposed to give legal consultation on the spot right here. That's not the purpose of my presentation. And if you guys have really specific legal questions, or if you're thinking about eviction, please contact my law firm and we can help.
Thank you, Ms. Deely. I do know that we did have the promotion for this morning's meeting to be about arbitration and mediation, but we also know evictions was a very, very hot topic with the eviction moratorium coming at the end of this month, that she went ahead with the topic of evictions instead, and she can come back next time with the arbitration.
Yeah, if you guys are interested in arbitration mediation, I don't know if you guys have experience in that or want to know more about that, I can back and do another presentation at a time. Thank you.
Anybody here have a question?
I have 2 questions. On an average, how long does it take for the sheriff to come out after they receive the writ?
Good question. Okay, so typically, I would say it takes about a month or so for them to post that final 5-day notice on the door of the tenant. So from the final 5 days to the actual lockout, maybe another week or 2.
For the security deposit, what are the different uses, does the landlord have for the security deposit?
So for security deposit, there are also specific rule written in the code, I believe the code of civil procedures. After the tenant moves out, meaning that, after the landlord officially regains possession of the property, you're supposed to return all the deposits in 21 days. And if you're deducting any deposits, for example, if there are, damages to the property that you're using the deposit to cure for, then you're supposed to give a notice along with a itemization of your deduction. You're saying, okay, I spent $100 on fixing the windows, or another $200 on fixing the carpet, and so forth. Well, I'm not talking about normal wear and tear. Okay, I'm talking about more serious damages to the property. So within 21 days after the tenant moves out, you have to give this notice with a itemization of the deduction of this. That is written in the law. You have to do
Okay. So you have tenant that's been paying rent, charge, but it's been there for over a year. So now, but you want to, get them out, terminate the lease. So you got to give them 60 days, right? Notice? Okay. After you serve the 60 days, nothing happened. They don't move out. Now, do I go back and give the 3 days notice?
You don't have to. No, no. You can start the lawsuit, the eviction lawsuit.
After 60 days.
Yeah.
So go to
Because
step
you're not suing. So here's the tricky thing. What is your ground for eviction? In this scenario you just mentioned, you're suing because he's not complying with the 60-day notice. You're not suing because he's not paying rent. If he's not paying rent, then you have to give a 30-day notice. So there are also scenarios where you have to give 2 notices. So we have to know more about the facts and how much payment, rent payment he's being late for and so forth.
So late. He's been paying on time. I just want
even after you give the 60-day notice, he's still paying rent.
Well, he doesn't pay. He doesn't move out. He's still paying rent.
Okay, well then you can evict based on the 60-day notice that you provided. But we also have to see whether this guy is affected by COVID-19 somehow. Whether you've given those, there are a ton of notices that the landlord has to give, not just those notices, but also notices specifically designed for COVID-19. We will have to see. But 60-day notice is what you need to terminate the lease. For the lease term that lasts more than a year.
My question is, I've had several, like one case that tenant filed bankruptcy before the sheriff.
That is the biggest nightmare. So
also, if there are any other creative ways of handling it.
So I've done UD for about 7 years now. I probably dealt with, I would say, less than 5 cases where the tenant filed bankruptcy in the middle of a UD case. This is very common nowadays because of COVID-19. It's a delay. Okay, so because the minute that tenant filed bankruptcy, the court that handles UD no longer has jurisdiction. It's the bankruptcy court, bankruptcy judge has to hear this case. And the bankruptcy judge will put an automatic stay on the property of the house. So you cannot even evict him anymore. In that situation, the landlord needs to consult with the bankruptcy attorney on lifting the automatic stay. Basically, I'm not telling you what to do, okay? But the general idea or the basic rationale behind this is you have to explain to the judge, look, we have a UD here. This property is not a tenant property. It's my property. So can we please lift this stay on the property so I could continue the UD case? That the judge will most likely grant that automatic lift, but it would just take time, and it will cost the landlord a couple $1,000s more on top of the UD case just to hire a bankruptcy attorney and complete that step. So it is the biggest nightmare we have for UD cases because it will prolong the process by another month or so at the minimum.
These are from Zoom. So there's one, I know you mentioned a 30-day and 60-day notice depending on the term of tenancy.
Yeah.
This one is asking when is landlord required to serve a 60-day notice to vacate as opposed to a 90-day notice to vacate?
Good question. Yeah, 90-day notice is applies when I believe when the property is under rent control. So especially in LA City and the nearby areas that's under the rent control ordinance or controlled by the rent control ordinance, there are additional requirements that the landlord has to meet in order to terminate the lease or vacate someone. They have to get the city involved. So there, and the termination notice is, I believe, 90 days, but don't quote me because we don't really handle rent control issues. But I believe that's what the 90-day notice is required for.
Okay, thank you. Sorry for those on Zoom, we didn't realize the mic was off.
Oh, no.
So hopefully they still heard the questions. The next question on Zoom is, when the tenant just vacates and owes past due rent of several months, what legal steps need to be taken to obtain a judgment? Does one just go to collections?
Another good question. So this is also very, very commonly asked by my clients. So hopefully you successfully evicted the tenant, and now is how do I get my money back, right? How do I get those unpaid rent back? You have to sue the tenants in small claims or most likely a small claim court. Maybe in certain cases, it's in the civil court if the amount is huge. But I would say 90% of the time it's probably small claims to get a monetary judgment against the defendant. But the hard part is at this time, you don't know where the tenant is. Tenant has already moved out and left. You don't know where he is located. You don't have his address. You don't even know, you don't know his whereabouts. Even if you obtain a monetary judgment against him, how will you collect? So execution of the judgment becomes another hurdle they have to jump through. You could hire a collection agency to help you collect, but you have to have a judgment first. I don't think the collection agency has the right to demand payment from someone just because, So you will, the first step would be suing the tenant for damages, for monetary damages, for small claims or something. Oh, I just want to add, we also advise clients to do a asset search of the tenant and also an address that's called a skip trace. Basically, the search of the tenant whereabouts, the location, any bank accounts he has, any assets he has. And this is important because, like I mentioned, if this guy has no assets whatsoever, even if you get a monetary judgment, you're not going to get any money back. So that's something to keep in mind. That you might want to find out whether the tenant has assets before you start a litigation or damages.
Thank you. The mic keeps going off on its own. Next question is. Okay, the next question is this UD unlawful detainer process the same for residential and commercial tenants? If it's a little different, can you explain how?
For the most part, it's the same. The same rules that apply to both tenants, whether it's commercial or residential. But the biggest difference is that those eviction moratoriums, both of them don't apply to a commercial. The eviction moratorium is designed to protect individual personal tenants. But it also depends on the lease agreement. So we will have to see what the
For City of Los Angeles, if there's a tenant buyout agreement in place, do you still have to serve a notice to vacate?
Sorry, I didn't get it.
In City of Los Angeles, if you have a tenant buyout agreement in place, do you still have to serve? Yeah, do you still have to?
You have to serve a notice no matter what. That's the very first step. It applies in all situations.
Okay, one very last question. I know she stood up early, just really quick.
What do you require to pay tenant relocation assistance?
Okay, good question. So relocation costs is very commonly seen in rent control properties. I believe the city of LA or the rent control ordinance requires a payment of relocation costs in order to have tenant move out. And also, depending on the ground of eviction, if you're evicting for unjust cause, for example, you're evicting because you want to sell the property, right? The tenant didn't do anything wrong. And you want to get back property, then you might have to also pay your relocation cost. There is also rules on how much, depending on the terms of the tenancy and income level and stuff like that. So it can be quite complicated. No, actually does not. Yeah. I think the relocation cost doesn't necessarily correlate with the length of the tenancy.
Thank you, Ms. Lee. We do have more questions on Zoom that we couldn't get to, but if you have questions, you can contact Ms. Lee. Her contact information is on the screen. It's in Chinese. They are multilingual. But you can read the phone number. It's in English.
Yeah, I can speak Mandarin. In fact, this presentation, PowerPoint slides was prepared for a Chinese speaking audience, so I apologize for that. I can just quickly tell you. You can contact my office phone number if you want to consult with us or if you want to start a eviction case. You can also check out my website that has all the practice areas that we do. So I personally handle trademarks for intellectual property cases. And then I have a team of 3 attorneys at my office who have different areas of expertise, including immigration, including real estate. So yeah, you can check us out and just call us if you need help.
Thanks so much for that. Very informative talk. And on behalf of the Western Rural Valley Realtors, I have a little bit of a token of appreciation for your time. Can we take pictures together? Yeah. Yes, you should. You take one with my phone. Oh, thank you. And next we have our attendance drawings. All WSGVR members are included in attendance drawings. Not all can be displayed, but all are included. Today's pot is $50. If you don't get a winner, 25 will be added to the pot each week until we have a winner. If we get a winner, pot will begin again at $25. If for our last breakfast meeting of the year, we still do not have a winner, we will draw names until we have a winner. Winners must be present in person with the association to win. When your name is called, you must announce that you are present. If you call your name 3 times, if we call your name 3 times and you do not respond, we'll move on. And here we go for the spin.
Give me 1 second. All right.
And drum roll. Jennifer.
Janata.
Nada. Jennifer. Going once.
Oh, not here.
Going twice. Okay, we're going to move on to our Amazon gift card drawing. We will select 3 winners from those attending today, who will receive $25 Amazon gift card. We have Steve Potts. And Lucia from Freepa.
Oh, yeah.
And Mel Wong. Congratulations. Please come up to say your private. And the Education Committee invites you to participate in their upcoming Foundation for Success in Commercial Real Estate class. The class will be held at the association on March 28th and 29th. The cost is $325 per member. Please make sure to participate in our educational classes. And they are Foundation for Success in Commercial Real Estate, which is again March 28th from 8:30 to 5:30. Commercial seminar, basic of real estate investments, apartments. So that one's interesting. Tuesday, April 11th from 12 to 1. The CRMLS virtual training. It's Wednesday, April 12th from 9 to 10 and 45 hours DRE license renewal on April 14th from 9:30 to 12:30. Please make sure, let's see. Okay, next is our 50-50 raffle. And the pot for the day is $54.
Oh.
3722594. 3722594. Yeah, and you're the only one. Awesome. Come on up.
Check the ticket.
Okay, before we end our meeting, if there is anyone who would like to do a pitch of their listing who didn't register previously, can come up with a flyer. Anybody? And join YPN for a networking mixer at Barcadia in Arcadia on March 30th. Please purchase your e-ticket online by going to www.wsgbr.com. So please join us next week, March 30th. Our speaker will be affiliates Nancy Chang, Alina Hsu, Jacqueline Hsu, and John Wax. Their topic will be on nothing is certain except for death and taxes. Thank you everyone for joining our meeting today. This meeting is now adjourned.